We're looking into Thompson Newspaper Limited versus Canada, and we find the following written here. While individuals, as a rule, have full legal capacity by the operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state. His rights are such as existed by the law of the land, long antecedent to the organization of the state. So here we're learning, right, that the rule of law is that individuals have full legal capacity by the operation of law alone. So every individual has rights, and these rights existed by the law of the land long before the organization of the country, long before Canada, and long before America ever became a country in law. These rights that you have were not created by the government, but the government is under obligation to respect these rights. And you want to know what those rights are called? How they are identified in law? They are called natural rights. Now look at the definition here of a natural right. A right that is conceived of as part of natural law, and that is therefore thought to exist independently of rights created by the government or society, such as the right to life, liberty, and property. So a natural right is part of the rights that you have, and those rights exist independently of rights created by the government or society. That's why we see the court judgment here say that individuals, as a rule, have full legal capacity by operation of law alone, and that his rights are such as existed by the law of the land long before the creation of the state. Why? Well, that's the very definition of a natural right. It is thought to exist independently of rights created by the government. Standing under your natural rights or invoking your natural rights, that is what is recognized as the full legal capacity. You have these rights. No one gave you them. That is your full legal capacity. However, in 2025, the natural rights that you've just saw and just learned about are not designated natural rights anymore, even though they are natural rights. R versus Wagner, the rule of law. Finally, at the developing fringes of the new natural law, which goes by the name human rights. So your rights that you have that existed long before the creation of the state, that operate apart from the government, they are called human rights. When you stand under your full legal capacity, you are standing upon or under your human rights. And those human rights don't exist because the International Covenant said so, or because the Charter of Rights and Freedoms said so. Your human rights, your natural rights, exist independently of any government body, of any government authority. Your rights are there. Whether you want to say unto yourself, it's because men recognize these rights in nature, or because God gave you these rights. That's up to you. But nevertheless, you have these rights. Not only that, right, but the government also is aware and also knows that you possess these rights. Because what we just read here is a court judgment. The Thompson Newspaper Limited versus Canada. That's the judiciary of Canada. And they wrote that individuals, as a rule, have full legal capacity by operation of law alone. His rights exist by the law of the land long before the organization of the state. So they made a statement. They made a declaration. And the declaration they made is that we recognize that individuals have natural rights, have human rights. And these rights exist not because the government created them. And what you just listened to me teach you and share with you, that is the rule of law. It's not necessary to try and prove this. And it's not necessary to try and claim this. Why? Well, because they already recognize it. And it's a rule of law. And it's a fundamental rule of law. So it's a primary rule of law. So you don't have to prove it. It goes on to say that artificial persons are creatures of the state and enjoy civil rights and powers, not natural rights, not human rights, but civil rights. Now, artificial persons are statutory creatures. They're created by law. They don't operate under full legal capacity. Artificial creatures such as the driver, or the hunter, or the student, or the consumer, or the patient, or the homeowner. These are all designations in law. These designations have been created by statutory law. They were created by government laws. So just as you see, a natural right exists independently of rights created by government. So the rights created by government are statutory rights, and they operate only upon statutory creatures. The Emergencies Act of Canada. And whereas the Governor and Council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights, and must have regard to the International Covenant on Civil and Political Rights, particularly with respect to those fundamental rights, not civil rights, but fundamental rights that are not to be limited or abridged even in a national emergency. So as a man and a woman, you have rights. And these rights exist by the law of the land, not because the government created it. And those rights are natural rights, human rights. And when you stand under those rights, you are standing in your full legal capacity. You are operating those rights. The government didn't give you those rights, but they must recognize those rights. And now we see here that there are fundamental rights that are not to be limited or abridged. They can never be limited. They can never be ignored. The government can never ignore them, even in a national emergency. That's the power of your human right. That's the power of natural rights. And that is the rule of law. Court judgment, Supreme Court, Christie versus British Columbia. The rule of law, a fundamental principle of our Constitution. So the rule of law, it's a primary aspect. It's a primary power of the Constitution. And it must mean at least two things. First, that the law is supreme over officials of the government, as well as private individuals. So, the rule of law that states that you have natural rights, that you have human rights, and these human rights are never to be limited or abridged, and that's your full legal capacity. And that law is supreme over officials of the government. The rule of law is that you and I have natural rights, human rights, and the government didn't give us these rights. And these rights are never to be limited or abridged by the government power. R versus Wagner. The rule of law, this rich intellectual tradition of natural law, seeks to give the law minimum moral content. It rests on the proposition that there is a distinction. There's a distinction between rules and the law. There's a distinction between statutory law and fundamental law. There's a distinction between statutory capacity and full legal capacity. Rules and the rule system can be good, but they can also be evil. And what Wagner is saying here is he's saying that when those statutory laws force people into recognition, and this recognition limits and abridges their human rights, when this recognition places limitations and abridgments upon the rule of law, upon foundational law, then that is evil. He goes on to teach us, thus, as important as these principles may be, and as essential as it may be, that in difficult cases, the judge must stand against the winds and rains to uphold them. He must stand against the executive powers. He must stand against the legislative powers. He must stand against the statutory law that are placing limitations and abridgments upon natural rights, upon the rule of law. And notice how he says that it's essential. And why? Well, because if you call yourself a lawyer, and if you call yourself a judge, right, then you have the duty and you have the obligation to respect the rule of law. That's your primary obligation. Not to respect statutory law, but to respect the rule of law. Those unwritten principles tend to be largely replicated in the text of the Constitution, with Section 7 of Canada's Charter of Rights striking me as a prime example. Our written Constitution reflects many, many influences, including the drafter's awareness of natural law. So he just told you, right, that those unwritten principles of natural law that state that every individual, every man and woman possesses rights that they are born with, possesses rights that are not given to them by the government and are not created by the government, but must be respected by the government. He said those rights tend to be largely replicated in Section 7 of the Charter of Rights and Freedoms. He didn't say only or exclusively. He said largely. So Section 7 is not all and all. It's part of it, but not the all and all. That's why when you look to the Charter itself, in Article 26, it states this: the guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. So Wagner just said, he just told us that Section 7 of the Charter of Rights and Freedoms is bringing forth natural law. That's what it's bringing forth. Well then, look what Graham Grayton said, another judge. The Canadian Charter Rights Decision Digest, Justice Canada, read as a whole, it appears that Section 7 was intended to confer protection on a singularly human level. A plain common sense reading of the phrase, everyone has the right to life, liberty, and security of the person, serves to underline the human element involved. Only human beings can enjoy these rights. Everyone then must be read in the light of the rest of the section and defined to exclude statutory creatures. Only human beings can enjoy these rights. Why? Well, because their natural rights, their human rights from natural law, from the international covenant. They provide the rule of law. And that's why it only applies for a man and a woman. The Universal Declaration on Human Rights. Now, this is not a binding document upon the state parties, but it brings forth an expression of natural law that finds itself afterwards contained in the covenants. It says here, all human beings are born free. So, a natural recognition, a natural right, is that we as men and women are born free. Now, with that word free, it automatically brings forth subsequent consequences or subsequent realities concerning freedom. Because if you are free, then you have the capacity to remain free. And the only way your freedom can be changed is if you willfully give it up and surrender it, or if someone takes it from you. The ICCPR, Article 16, everyone, that's the man or the woman, shall have the right to recognition everywhere as a person before the law, has a right to recognition everywhere as a statutory creature before the law. Now, in Article 3 of the Constitution Act of Canada, it says every citizen of Canada has the right to vote in an election. So a right does not produce an obligation, but a choice, a capacity to operate as or operate in. So the citizen has the right to vote, but they're not forced to use the right to vote. And the human being has the right to enter into recognition as a statutory creature before the law, but is not to be forced to enter into recognition. And if someone is trying to force you, then they are breaching the rule of law. The Justice System of Canada states that Article 16 of the ICCPR guarantees to all human beings the basic human right to be recognized as a person before the pursuant to this provision. The individual is endowed with the capacity to be a person before the law, to be recognized as a potential bearer of legal rights and obligations. So the man and the woman has the capacity to potentially, but not an obligation to. Some will come across some doctrines and some teachings on the internet, and they get a hold and they get a grasp of the fact that there's a difference in law between a man and a statutory creature. And they think the remedy to that is to simply claim, well, I'm not acting as a statutory creature, therefore you can't regulate me because I'm a man. And then they wind up getting themselves in trouble. The concept is correct, but how you're exercising the concept, how you're exercising the right is incorrect. First of all, you should always have a claim of recognition in play on your behalf, already sent to the heads of the government, so they know your position and they can't use the color of law against you. And if your human rights become under attack, because the public official is continually trying to force you into recognition as a person before the law, then just claiming that you're not that person, that you're not a statutory creature, is not enough. If you wind up going to court, you have to show the judge how that placing you into this capacity as a statutory creature is limiting and abridging your fundamental right. And what is your fundamental right? Well, I have the capacity, I have the potential to operate as a statutory creature, but no obligation. And because they're forcing me to take this recognition as the statutory creature, they're breaching my fundamental right as found in the ICCPR. That gives me the choice. So in essence, what are you doing? You are showing them that the rule of law is being broken by the actions of the public official. I was born free and have the capacity to remain free, but they're trying to force me to take recognition as a statutory creature. And by forcing me to take recognition, they're breaching the rule of law. They're breaching a fundamental principle of justice that is found in international law that says it's up to me if I want to decide to take recognition as a statutory creature before the law, not that I can be forced.
Don't forget to hit the like and subscribe to my channel. And don't forget to turn on mobile notifications for new videos.